what I'm going to do is take a few minutes to introduce Justin Sterling and then have him spend a little bit of time introducing himself and his work. And then we're going to sort of roll into the contract fundamentals for producers lecture. I've known Justin Sterling now for about a little bit more than a year, I think. And one of the things that stands out is that he is incredibly helpful to people. In addition to the fact that he's a litigator with a very strong background in entertainment law as well as in litigation, he also is a great source for referrals. So if he can't provide you with a specific type of information or support, he can refer you to somebody else who has that information, because he spends enough time networking to know people in the entertainment community and here in Los Angeles that work across a wide variety of disciplines, whether it's securities law or entertainment law, or people who work specifically in literary law, like book rights and so forth. So he has a very bad background, and so I hope you'll consider him a resource that you turn to on a regular basis. This particular presentation is about contract fundamentals, and the reason that I think it's important, or I wanted to run this particular event, is that anybody who's producing an independent film, particularly one at the micro budget level, is going to end up making dozens or hundreds of agreements over the course of the operation. They need to know the fundamentals of how to make an agreement which is enforceable. They need to know how to avoid making that agreement by accident, and they need to know when they must get a lawyer involved in order to protect the rights of their rights as an entrepreneur and the work that they're creating for sale. I'd like to take Justin Sterling take a few minutes to introduce himself.
All right, thank you, Nancy. Yeah, I just want to say first, thank you for putting this on. Nancy, I mean, you do such a great job. You offer such valuable information to everyone involved with all your groups. So I just want to say thank you. Yeah, my practice is, the majority of my cases is litigation in various different fields: entertainment litigation, business litigation, personal injury. I also do transactions. But yeah, I find cases all different, they come from all different, the facts are all very unique. Very unique situations, these disputes arise. But these fundamentals of contracts is very important for anyone in the entertainment industry, business, because you get involved in disputes all the time. And if you don't know what the agreement is, what the terms of those are, what are the duties on each party, what are the obligations, you're going to run into disputes. So I'm hoping with this presentation that the listeners will gain a foundational knowledge of knowing how to make an agreement, what is involved, and to be clear and certain with the terms, so each party knows exactly what needs to be done. As far as my practice in entertainment, I've worked with independent film producers, I've worked with artists, I've worked with writers, and there's just so many legal issues involved, that it is important to work with an attorney and basically grow with that attorney as you go forward in your entertainment career. So I'm just really happy to be here. I'm happy to be of service. I stay involved with the community, the entertainment community, the legal community, and yeah, I do have many contacts, and we help each other. If there's an issue that I don't know, for example, Nancy's great with securities and investors. So if there's a practical issue that I'm not very experienced with, I pick up the phone and I call Nancy and I get some guidance, so we can help each other and help people that we serve. So I'm just very happy to be here, and looking forward to doing this presentation.
I've never referred somebody to you who hasn't come back and said that, you know, you knew the information, and also many of them have come back and said that you've given them good referrals. I mean, you make great recommendations to people. So you're kind of a one-stop shop, you know. Let me go ahead and, so do you want to go ahead and just get started and see how things go?
Yes, let's get started.
All right, cool.
Well, here, the first point, learning how to define an agreement and how to avoid contracts by accident. I think that's very important. What a lot of people don't understand is that a contract does not necessarily have to be in writing. You can create contracts verbally, and you can create them verbally, and you can create them through multiple writings, emails back and forth. The underlying premise of contracts, of contract law, is to hold people to their promise, is to hold people to their word. And so what the courts have a great challenge with is trying to find out what exactly is that promise, what exactly is the agreement. So many times if you have emails going back and forth, you can bring all those writings in, and all those emails, all those writings create the contract. All those various written memorandums, they'll bring it in to get what was in the mind of the parties. What was the meeting of the mind is what the court is trying to get at. The legal definition of a contract, including the basic elements required to make them enforceable. In every single contract, there are some essential elements. It's an offer, an acceptance, and a consideration.
Cool. So should we go on to the? Should we actually go on to the next slide and then? Yes.
Sure. Yeah. Let's go on.
Okay. Cool.
Just making sure
you could just say next whenever you want to go on to the next slide.
Sure.
Cool. Okay.
All right. So yeah, as an independent producer, you're dealing with contracts all the time. You're dealing with releases. You're dealing with location releases, performance releases. You're dealing with intellectual property rights. It's very document heavy, and you need to create your paper trail. That's your chain of title. And if there's just one contract missing, that could create a cloud on your title of your finished product, and that can stop distribution. It could just ruin the whole project. So it's very important that you have your whole house in order, that you have all your documents in place and they're airtight, that there's no missing language that could make a contract invalid. You just want to make sure you do it right, because that chain of title is very important in getting your distribution deal, which is really your main goal, is to get your work out there and exploiting it and showing it to others, because that's what you're building. And also to get insurance, E&O insurance. The insurance carrier is going to want to see all that chain of title. Let's see, what else is there? Funding, of course. You're dealing with some investment contracts, which get very complex. You're dealing with securities laws. We spoke earlier that you'll want to consult with the securities attorneys, because when you're using the documents, the disclosure documents to acquire funds, they cannot be misleading. They cannot have any misrepresentation. So they have to be very airtight as well. So where else are we? It's quite possible to make contracts unintentionally in order to make contracts that make your project impossible to produce or to produce profitably. Again, contracts, not all contracts have to be in writing. You can make them verbally. And if you're sending emails back and forth, you have to be careful of what you're emailing, because you could bind yourself, and you could bind yourself in a way that you don't want to. So it's very important, say, if there's a distinction between negotiations and finalizing an agreement. So in your language that you use in any correspondence, you want to say that further assent is required. We are in mere negotiations, something of that sort. Say, I appreciate this. You want to be more or less formal. You can say, I really appreciate this. I still consider us negotiating this. I'm not ready to finalize any deal. I'm considering this. I still want to work out the terms. This is not final. Just, you want to be clear, because those written emails back and forth, you could bind yourself unintentionally.
Very
So
cool.
next slide. We go.
Cool.
Again, we were talking about not all contracts have to be in writing. They can be oral, verbal. However, certain contracts based on common law must be in writing. And this is according to the statute of frauds. The statute of frauds requires certain contracts to be in writing. And historically, this was to avoid fraudulent claims. However, just as a practical note, this statute of frauds doctrine has actually enabled fraudulent claims. All right, it's a little difficult to explain, but there's certain contracts that must be in writing, and there's 5 of them. There's and we use the mnemonic so we can remember my legs. MYLEGS, my legs. So any contract in which marriage is consideration, a marital agreement, a prenup, that must be in writing. Same thing with the 1-year provision. Any service contract that cannot be finished within 1 year must be in writing. There is a nuance there. Lifetime services contracts, all right? You can enter into that, and you would think, oh, that's a lifetime. That's going to go over a year. But you could enter into that, and you could die the very next day. So that can be completed within a year. So anything that requires more than a year in any services contract must be in writing. Another category is land. Anything dealing with land must be in writing. A real estate transaction, a leasehold must be in writing, because land is considered unique. So even when you're dealing with any type of property, like even possibly a billboard advertisement, that's space, that's airspace, that's unique. So that must be in writing. An executorship for a decedent, that must be in writing. Also, based on common law, goods over $500. Anything in which there's a sale of a good over $500 must be in writing. A good is defined as anything that's movable at the time of transacting. All right. Pursuant to the California Corporations Code, I believe it's anything over $1,000. I believe it's the Corporations Code. It might be the I forget what code it is, but it is, I believe, over $1,000 here in California. Any good over $1,000 must be in writing. A suretyship must be in writing. A suretyship is a promise to satisfy the debts of another. That must be in writing. All right, so that's just some background there as far as what contracts must be in writing. And also pursuant to statute, there are certain contracts that must be in writing. We can go on to the next slide. For independent producers, this is very important. Your work for hire agreements. A lot of times you'll be obtaining the services of various people through independent contractor agreements. You may not want to employ them, because once they become an employee, you're subject to a lot of employment law, labor code requirements, such as providing workman's comp, payroll, many different other requirements. So you may want to retain the services of an independent contractor. However, you want to be able to have all those rights. So you're going to want to enter into a work for hire agreement. And pursuant to the Copyright Act, that must be in writing. And here this lays out Section 101 of the Copyright Act. A lot of times you'll be dealing with, as an independent producer, you'll be dealing with subsection 2 as a part of a motion picture or other audio visual work. There's certain words that must be included in these agreements. It must specifically say the work is considered work made for hire. All right, so that's very important to have those words in that agreement. You can go on to the next slide.
Very cool.
So what is a contract? Okay, a contract is a legally binding or valid agreement between two parties. It consists of an offer, an acceptance, and consideration, and it involves mutual assent, the meeting of the minds between the parties. It is holding people to their word. We want people to be trustworthy, and if they're going to make a promise, we're going to make sure that they actually follow through. So that's the basis of what a contract is. We can go on to the next slide. So again, we said that there must be an offer and acceptance. There must be an intention between the parties to create a binding relationship. So that's you're getting into the objective manifestations of the parties. It's not the subjective intent. They must objectively manifest that intent to enter into an agreement, to bind themselves. It's not, it's not what someone's hidden agenda is. If they're saying, oh, if they're behaving one way, but in the back of their mind, they're saying, oh, I don't really mean this. The law is not going to consider that. Consideration to be paid for the promise made. There must be consideration because there must be an exchange. It must be reciprocal. It must be bargained for. There must be what we define as a legal detriment and a legal benefit. You're giving up something to gain something. Each side is giving up something to gain something. It's, again, reciprocal and mutual. The legal capacity of the parties to act, they must have the ability to understand contractual rights, the genuine consent of the parties. Again, that gets into what we call the objective theory of contracts, and the legality of the agreement. You cannot make an agreement to do anything unlawful or to commit a crime. And so those are the requirements for a contract. If it's missing one thing, you don't have a valid enforceable agreement. So you have to make sure you have all these elements. We can go on. So an offer and acceptance. If someone offers you something and you accept it, you got one element of the contract. If you offer someone something and they accept it, you've got another element of the contract. And again, this something can be a product, a service, a right, permission. That something is considered the consideration. You really can do contract for anything so long as it is not a sham, it's not one-sided, and we'll get into that a little bit later in this presentation. And it can be verbal, in writing, and value is in the eye of the beholder. The courts will not get involved in determining what is fair value. They're not in the business, the courts, judges, we're not in the business of determining the worth of something. One man's trash can be another man's treasure. So value is very subjective, and the courts will not get into that, so long as it is not a sham. That's the key term here. It cannot be a sham. It can't be a contract for something that someone was already obligated to provide. That's called the pre-existing duty rule. And yeah, we can go on. So the definition of an offer, this is more of a legalese definition. And we can break this down into each phrase here. So an offer is a manifestation, that outward, objective manifestation. Again, we're not considering someone's subjective intent, all right? So an offer is a manifestation of a willingness to enter into a bargain so made, and that's important, so made that justifies another, that their assent is invited and will conclude the deal. It creates the power of acceptance in the offeree. The terms of the offer must be certain, definite, and clear, so that the person knows what they're agreeing to. That power of acceptance that's very important. They have the power of acceptance. They have the power to reject this offer. We can continue. So an acceptance is an objective manifestation of assent by the offeree to the terms of an offer made in a manner that was invited or required by the offer. Again, going back to the offer, it creates in the mind of the offeree that their assent is invited and will conclude the deal if they just agree to the terms of the offer. So those terms have to be very clear and certain. They can't be ambiguous. They cannot be vague. They have to know what they're agreeing to, because each party has to be on the same page. There has to be a mutual understanding, a meeting of the minds. And these are terms that I'll say often throughout this presentation because it's important. That's what the courts will evaluate when there's any dispute, when someone's bringing a cause of action for breach of contract. They're going to get at what was the agreement. What did the parties come to a meeting of the minds about? And it's very important also if you're entitled to injunctive relief, which is in contract law, it would be specific performance. That's an order by the court to actually do this agreement. So there's certain elements that must be met in order for the court to provide for specific performance of a contract. And there's special elements that must be met because the courts aren't really in the business of telling someone to do or not do something. So it has to be unique. This contract must be unique for the court to say, you have to perform this. We can go on.
Actually, I just wanted to ask a quick question. When you said objective manifestation of assent, so in a lot of contracts, it'll say, by signing your signature below, you are agreeing to this deal. So that's because the signature is your objective manifestation of assent. That's it's telling you, the contract is telling you have to sign here for the deal to be enforced, and you sign your name. So there's something objective that people can look at to say that you agree to this deal. But you can have the same thing in an email. If I say to you, send over your laundry, and we'll get started. Then if you send your laundry, then you want to get started because that's an objective manifestation of assent. So it doesn't have to be a signed contract. It can be if somebody says, if you do this, then the deal's on. And if you do that, then the deal's on. Is that correct?
Yes, there's certain ways, unless the contract calls for a specific way to accept this agreement, there are different ways to show your acceptance. And one way is to accept by conduct. If you actually take steps to perform this, then the courts will say that you've accepted this offer. Again, it's the objective manifestation, which can be shown by conduct. I think also what you may be getting into as well is something that we refer to as the parallel evidence rule. When we try to get at what exactly was the agreement, the courts may look to parallel evidence, P-A-R-O-L, parallel evidence. It's not parole. It gets confused a lot. Parole is, when you get in prison and then you get out on parole. This is parallel evidence. And what that says is in certain contracts, the courts may look outside the four corners of that written document to determine what the parties actually agreed to. So they may look at other memorandums, other writings, emails of the parties, communications between the parties to get at what was that full agreement. But those writings must not conflict with the written document, all right? So they must basically aid, facilitate that agreement, bring in any added terms that does not directly conflict with the four corners of the document.
Cool.
That kind of is outside this presentation, but you guys should be aware that there is a concept, a doctrine in the law known as parallel evidence rule.
Very cool.
But you're right. Also, you can accept a contract by conduct, unless there is the contract calls for a very specific. Some contracts will call for acceptance by conduct, and then take this situation. which we've learned in law school, they always cite to the situation of what if there was an agreement that says if you swim across the river, we'll pay you $1,000. All right.
Mm-hmm.
Some person sees that offer, jumps into the water, and starts swimming, right? But then before they get to the end, or they get maybe just halfway, the person who made that offer says, "No, I am, I'm rescinding the offer. There is no more offer on the table." But that person's already started to swim. So do they have any recourse on that? Again, the courts will probably look, they accepted it by conduct. That offer was so made that justified another person that if they took that conduct, they would be, they have accepted that deal. Now they're back to the offer though. That offer has to be specific to the person. All right. You can't make, a general offer, there has to be some sort of distinction there. Who is the offer made to, right? Are you that person who that offer was made to? So that's another fine line in the law as well. But that person who started swimming across the river, their recourse could be, well, I accepted it by conduct. And even if they stop, they could say, well, I substantially performed.
Right.
That's a defense to, the enforceability of a contract, that I substantially performed this agreement. So I deserve to be compensated.
And that was why I wanted to just, we can go on to the next slide. That's why I wanted to briefly touch on it, because I think a lot of people, a lot of times when producers get into trouble, it's because they make kind of a general, they'll be talking to somebody and they'll say, well, sure, that sounds great. If you do thus and so, then you can be a co-producer on the project with me. And then the person will do thus and so, and all of a sudden they've got somebody who thinks they're a co-producer because they heard the offer, and the offer was said, if you do X, then you'll be a co-producer. So they do X, so they think they're a co-producer, even though nothing's in writing. And when producers are first starting out, I think they make those kinds of, they don't realize that they're making an offer. And they don't realize that the fact that they've made the offer and somebody's accepted it means that if they have to terminate that offer, there's no contract which explains how that's going to happen. So you're obligated to figure it out either by negotiation or by discussion, or by through litigation. So one of the reasons I wanted you to talk about is specifically that conduct could be used to seal an agreement. So we can go on to the next thing. I wanted to make sure that people understood that conduct you can accept by conduct.
Absolutely.
Cool.
So intent is implied by people's actions before, during, and after an offer is made. Again, that will get at the court will look at all the interactions between the parties to determine what exactly was this agreement. Did you arrange a meeting specifically to talk about the offer? Did the parties take actions based on the offer and acceptance? Was the agreement memorialized in writing or email? Alternatively, did either party indicate an agreement had not been reached? Again, this gets to the objective theory of contracts. This brought up a good point. Did the parties take actions based on the offer and acceptance? There is another legal theory out there, another cause of action, where if there may not have been a binding contract, there may still be recourse for a party who relies to their detriment on someone's promise. That's called promissory estoppel. It's an equitable theory. It's not based on law, it's based on equity, and that it's based on fairness. And there must be a reasonable reliance on someone's promise, and there must be a detriment to that person for relying on that. You should just be aware on that. I would say it's not as strong as a breach of contract claim, but it is also another claim that you can have in any complaint any lawsuit that you may want to pursue. Promissory estoppel.
Great.
Yeah, we can go on. So, the objective theory of contracts. Because neither contracting party nor courts are mind readers, it is important that the existence in terms of contracts be determined from the outward manifestations made by each of the parties, rather than by each party's subjective intent. the party's intentions to be viewed objectively, not subjectively. I think we've already driven that home, but it's very important, and it is deserving of its own slide here, because it is the objective acts, what is communicated, that is what is going to be the deal. It's based on objective. It's not what you thought, it's based on the objective facts.
Cool.
Consideration. A lot of people have a difficult time understanding what consideration is. The definition, kind of how I've framed it, is a mutual, reciprocal bargain for exchange. So we can break that down. It has to work both ways. And it must be bargained for. It must be negotiated. It must be an exchange. There must be a legal detriment and a legal benefit. That is, something must be given up for something in return. And that something in return could be a promise to do or not do something, or it could be money. It could be a thing. It could be a property right. It could basically be anything. But there must be something, there must be an exchange. We can continue. So a bargain, what exactly is a bargain? It cannot be a sham. Basically, the courts will not get into value, but if you're paying 1 penny for $1 billion house, the courts are going to look at that and be like, listen, that's a sham, that they're being taken advantage of. They'll look at all the facts and say, this is a sham transaction. It's just not, it's not fair. It's just not legally fair. Past consideration is not sufficient. This is the pre-existing duty rule, or something that was made before. You can't recite that for another future deal. That comes into when you want to modify an agreement. Modification requires additional consideration. If you have a contract already in place, you guys are bound. But if in the future, if you want to change that contract, modify it, there must be an additional exchange, because that's a legal detriment, and you're changing it for your benefit. So there must be some sort of exchange there. There has to be consideration involved there, additional consideration. So it must not be a pre-existing duty. Again, you can't contract for something that you are already obligated to do. It's one-sided. So we can continue. Consideration can be money, it can be products, services, intellectual property, opportunities. Very little protection against making a bad deal, because the courts will not get involved into what is valuable. So yeah, we can continue. The law normally does not determine the adequacy of consideration so long as the consideration is truly bargained for. However, if the consideration is purely nominal, it is usually an indication that there was no bargain at all, but rather a gift. Many contracts will make a recital that the agreement is made in consideration of $1 paid and receipt hereby acknowledged. That's really just to cover yourself, so that in the future, if they ever come back, oh, there was no consideration here. Well, we have it cited right there and you acknowledged it. So we've met that requirement. And a lot of times, even when there's just when it's not dealing with monetary value, but it's dealing with maybe an opportunity or a promise to do something, or even intellectual property, if you're exchanging some property right, you may want to include this phrase in there just to be clear that there is consideration involved here. And on top of that, you're making a $1 payment. A lot of contracts do have that. Although I personally, I don't always feel comfortable with that phrase, but we still put it in there in a lot of contracts. Mm-hmm. The legal capacity for the parties to act. So really, for a party to have the contractual capacity, there's a couple people who come into issue. Minors is very important, especially in the entertainment industry. When you're contracting with a minor, there's a lot of rules required for contracting with minors, which we have slides on that, I believe, next. And your mental competency. You have to have the ability to understand what rights are being transacted here. So that is the threshold of contractual capacity. So with minors, children under the age of 18 can only enter into what we call voidable contracts. So the minor can void that contract. The person dealing with the minor does so at their own risk. The infant may void the contract. Even approval of the contract by the parent or guardian of an infant does not bind the infant. So here in California, I think the next slide addresses this. We have the Accouting Law. Yes, here we go. So most contracts for minors in the entertainment industry are employment contracts for services. So in California, there is a need in the entertainment industry for certainty in contractual rights in order to facilitate the production, distribution, exhibition, and exploitation of the project. So California, because most entertainment deals are entered in California and New York, each state has adopted its own laws dealing with minors. In California, there can be court approval of the contract. So California has passed legislation that limit the infant's right of this affirmance so long as there has been court approval of the contract. So you can enter a petition to the court to approve the minor's contract, and either party can do that. The minor can do it through an attorney, or the employer can do it as well. And that also, it goes for loan-out companies as well. Loan-out, because a lot of services of actors are offered through loan-out companies. So if you're contracting with a loan-out company, you still should petition the court to approve that contract, because you're still considered the employer of the minor, even though the minor is offering services through a loan-out company. And as the Accouting Law also requires that 15% of the minor's gross earnings be set aside in a trust for the benefit of the minor. It can be agreed to set aside a higher percentage as well. And that's all codified in the California Labor Code. Also, the California Family Code, it also addresses some of these issues. The Accouting Law encompasses sections of the Labor Code and also the Family.
So this doesn't apply just to kids that are part of the union. This means any child that you put into a film. Yes,
any child under the age of 18 or that has not been declared emancipated.
So that means that if somebody it's not okay just to, even your own kids, it's not okay for you to basically say, I'm going to put you on camera, or your friends, your friends' kids. You can't just say, I'm going to put you, do you want to play a part in my film? I'm going to go, and you have to show up on this day, and this is when I'm not going to pay you anything, and because you're violating the Accouting Law, among other laws, right?
Right. And I mean, historically, child actors have been taken advantage of by their employers and family members. I mean, there's been situation, I believe, Macaulay Culkin has, you hear all these situations where these child actors are filing lawsuits against their parents because they've taken all their earnings. This law protects minors, so it requires them to set aside an amount for that minor for their own well-being. Really, that percentage is supposed to be the rationale is so that they have some funds from their earnings for their well-being and necessities of life.
Wow.
Contracts for necessities of life with minors which is basically outside the scope of this, they are considered valid agreements, and they're not, they cannot be voided. So contracts for necessities of life, you should just be aware, are an exceptions to the rule concerning minors.
That's cool. That's interesting to know.
We can continue. Genuine consent of the parties, consent given under duress. And then what we're getting at here is we're getting to defenses to the formation of a contract. There's various defenses, duress being one of them. Duress basically is that you're not making a decision of your own free will. And here we list violence, threat of violence, extortion, character assassination, but also as a practical matter, you should also be aware of economic duress is also considered to be a defense. So many times you can be pressured economically by another party to enter into a contract, and that could be considered a defense of duress. We can continue.
So like if your caterer shows up to your site and he wants to charge you twice what you agreed, and that's an example of economic duress.
Oh yeah, well, a situation is, he shows up to the site in the very last second, you're like, oh no, we're going to up the price. You're like, well, I'm already here, I have all my supplies here, what am I supposed to do? Like, oh, okay, we got to take it. But that was made under duress. His freedom of choice, the free will was not, he wasn't able to exercise his own free will under those circumstances.
Cool.
And so we have the definition here of what duress is. I'll just read it really quick. The defense of duress is available if the defendant can show that he was unfairly coerced into entering into the contract or modifying it. Duress consists of any wrongful act or threat which overcomes the free will of a party.
Cool.
The legality, again, I mean, this is, I think we all understand this. We can't contract to commit a crime. A lot of times, though, you may want to, when this comes up in my own practice, is a lot of white-collar crimes. You know, a lot of times when parties, this can be used as a defense of a contract. So a lot of times, maybe, you know, one party is trying to hold them to a contract, and wait a sec, this is an unenforceable contract because it's touching on some sort of fraudulent activity. So then it cannot be a valid contract because there's, you know, you're asking me to do something that will aid in a fraud. You can't hold me to that. And the other affirmative defenses to a breach of contract claim include economic duress we spoke about, a legal subject matter, undue influence. Undue influence is similar to duress, but it's not as high of a burden to meet for duress, so it is slightly lower. Against public policy, that's unconscionability. Maybe when we go back to that hypothetical, that scenario of buying a $1 billion house for 1 penny, that's unconscionable. It raises to the level that it shocks the mind. And no reasonable person would ever agree to this. It's just simply unconscionable. It's a high burden to meet. Also, there's fraud, mistake of fact. Again, mistake of fact gets into the meeting of the minds. If one person is mistaken as to what a certain fact is, then they're not on the same page and they cannot have a meeting of the minds. The novation is a separate agreement that replaces the prior one. So that prior agreement is not in place. The novation is controlling. Statute of frauds. Again, certain contracts must be in writing. Lack of consideration. And the statute of limitations you should be aware of for a written contract is 4 years from the date the contract was broken. For an oral contract is 2 years from the date the contract was broken.
That's cool. So
some jurisdictions have unique contract laws. especially here in California and New York. Again, ideas are free as the air, and that's in various court opinions. You'll see that expression, free as the air, which means generally if you tell the idea for your movie to someone, they can write a script based on it, and there's nothing you can do. It's that actual mental labor that is protected, the actual writing of the work that is what is protected under the law. You get copyright law as soon as copyright protection, the copyright adheres at the moment of creation. So the person who is actually exerting that mental labor of writing has the copyright. The ideas, we want to encourage creation. So ideas, we want people to be inspired. So if I hear a story and that inspires me, we're not going to hold that person liable for any wrongdoing because they were inspired by something. However, here in California, New York, where the entertainment industry is centered, ideas are very valuable. You go to these there's pitch conferences, there's pitch meetings, and your own idea is very valuable here in Los Angeles, in particular in the entertainment industry. So because California and New York have so many writers pitching ideas to studios, when they pitch an idea in a pitch meeting, excuse me, the writer owns the idea even though it's not written down. The producer can't use that idea without creating a contract with the writer. So that writer has a recourse, which we refer to as implied contract law here. And it's created by state court decisions here, state law precedents that shows that we will consider them to have a binding contract, even though it was just a pitch of an idea. But there must be certain elements that must be met, and I believe the next slide will detail that. So we can go on.
It's very cool.
So implied in fact contract. This is the legal concept. This legal concept is important in the scenario of an idea pitch. What you want to avoid is what we call the blurt out scenario, the blurt out man. For example, if you're in a cafe around here, or you're just on the street or whatever, you're talking over with a friend and you're speaking very loud about your idea, like, oh, I just got this new idea for a great movie, and the person next to you is listening, they can take what you just said and run with it. However, if there's certain elements are met, you can still be protected from having that other person take your idea. And essentially, there must be an aura of a business meeting. It must be a professional business scenario in order for you to be protected. So it takes a bilateral expectation. So in that professional business scenario, each party has a bilateral expectation that the party receiving the confidential information will compensate the other party for the reasonable value of the idea if they use it. A bilateral expectation is what creates the implied contract. So the courts will look at the factual circumstances, such as, was this idea solicited or unsolicited? Was there an opportunity for the person receiving that idea to reject it, to essentially say, no, I don't want to hear this, I don't want it? Or did that person just keep on talking without them, ever having the opportunity to, like, wait, I don't want to hear this. If you're going to tell me this, let's have it more professional. Business circumstances. Was it in the executive's meeting? Did you have your attorney present? A lot of those facts lead to the conclusion that this was a business meeting, and implied in fact contract law will apply. And the idea must in fact have been used. So they must have in fact used your idea. a lot of times there's a defense to this, that they had an independently created work already. So all because you tell them the idea, they had something already in the work. It was independent of you pitching your idea. So that is a defense to them for you coming and say that you infringed on my copyright, you breached our implied fact contract. They're going to say, wait a sec, no, we had something already, and it was just happenstance, and it was similar. We can continue. So this is, as a practical point here, this is how you can protect your ideas when you're pitching to any executive or any other producer. And you should be aware of this too. If you are a producer and you're taking on people's ideas, you should be aware that these are steps that should be taken in order to have those ideas protected. First, write it out. Write out all your ideas, because then you have a copyright in the work. Again, copyright adheres at the moment of creation. As soon as you write it out and express your ideas in any tangible medium, then you have the copyright. But still, that's not enough. You should register your work with the Copyright Office, not just the Writers Guild. I know there's a popular concept out there that, oh, I registered it with the WGA, so I'm good. No, the WGA does not provide you any legal rights. It just serves as like a third-party document bank, a third-party witness, but it's not the government agency. You have to register it with the U.S. Copyright Office. For writers out there, if there's anything that you take from speaking to myself or listening to this presentation or speaking to myself or any other attorney out there, is that you have to register your work with the U.S. Copyright Office. Also, memorialize all your meetings about any idea pitch or scripts or treatments. Memorialize it with a follow-up email. You just need to document things. Bring an attorney if you have an in-person meeting, or an agent or a manager or a third party. It creates more of a business setting. It also provides for a witness. If you are sending an email to memorialize a pitch meeting, copy your lawyer or agent, so it also creates that circumstances of a business submission. Make sure the cover of your treatment or script shows your WGA registration, your U.S. Copyright Office registration number, and your name, address, agent, and lawyer. Again, this is just a matter of professionalism, that this is your business, this is your career, this is what you do for compensation. So if anyone were to take your work or your idea, there's an understanding that you will be compensated. Reasonable compensation. We can continue.
Very cool.
So contracts create obligations and rights. Again, this is goes to making a contract by accident, maybe via email. You have to understand, once you have a binding agreement, that you will be obligated, that you have just obligated yourself to perform certain activities, or to give up rights, or or to acquire those rights. Calling someone your co-producer and telling people he's responsible for helping you produce your film makes him a co-producer. It gives him the right to produce the project with you. And without a well-written contract, you've got no way to terminate that agreement. The termination provision in a contract is very important. How are you guys going to exit this agreement if things go wrong? And how are you going to distribute what assets you guys have? So the termination provision is very important. A lot of people, they never really fully consider or evaluate that termination provision, but that's a very, very important provision in any contract. Offering the lead role in your project to an actor can be construed as meaning he has the right to play that role. You need a written agreement which outlines how the agreement can be terminated. Even these memorandum of understandings, a lot of times you'll see that rather than a full contract, you'll see a memo. Those memos can be considered binding agreements. All right, so you could be sued for breach of contract on those memos or those shorthand contracts. They can be still considered binding, so you should be aware of that. Offering people back-end points on the film creates the obligation to pay them. They have a right to ensure they are being correctly paid. You may end up in litigation on payment schedules. That's correct. You just have to be clear with your contracts, because you are entering into a binding agreement for which in the future could be the basis of litigation. We can continue. So for these projects under 100,000, there are a lot of contracts. This is your chain of title here, your script acquisition, talent acquisition, crew, location, distribution agreements, releases. A lot of things go into it. It's very document heavy, a lot of contracts involved. I do suggest to work with an attorney. These contracts make the film distributable and sellable. Again, if there's a cloud on your title, you're not going to be able to get a distribution agreement. They're going to want to see all your documents. That's what they refer to as chain of title for the screenplay. They prove the finished project is something you fully have the right to sell and license. Yes, you have to own all that title. There cannot be a cloud on it. A good contract avoids litigation and determines what will happen if the agreement is breached. It costs less than even the shortest court case. Absolutely. What you spend early on to get things right will save you so much later. Litigation is very costly and it can go on for many years. Just to file a lawsuit in Los Angeles Superior Court, a trial date is set out 2 years. So it's a long time, and it's very entangling, it's very costly. So we can continue. Working with an entertainment attorney. They can advise you on company structure and setup, along with the advice of an accountant, because there's a lot of tax consequences. They can create the standard contracts. I put standard in quotes because everything is unique. There's really not just one size fits all for these. You really have to get at what is being contracted for, what is the consideration, what rights are being negotiated. You have to be very specific and make sure you do things right. They will help you with rights clearances so your project can be sold without risk of having a cloud on the title. Again, we're talking about, for example, a big issue in film production is music licensing. I would suggest to hire someone to make your own music, your original music, because licensing music is a big issue in film. So that's just a suggestion. They are required to get E&O, that's errors and omissions insurance for your film, and you need it very early on if you're producing a true life story or documentary or work based on a newspaper article. Documentaries are very heavy in contracts and releases because you're dealing with individuals' rights such as defamation and rights of privacy. Same thing with true life story. We actually did a presentation not too long ago on these issues that you may want to look at. So they reduce your costs before, during, and after production. Again, it's important to work with an attorney throughout the process because you don't want to find yourself in a situation where it's too late and you end up in litigation, because it's just very expensive. I can't stress that enough, that litigation is very expensive and it can economically really hurt someone. So you want to avoid it at all costs and have that legal guidance from the beginning. Defending a suit, especially when there's no contract, is expensive and time consuming. It's very difficult to prove what the agreement is if there is no writing. Implied, I should say that that theory of law, implied in fact contract, is a very difficult, it's very difficult to prove in the law. It's much easier if you have things in writing. But implied in fact contracts are difficult to prove. We can continue. Okay, so I think that wraps it up. Here's my information. Feel free to reach out, contact me. I'm happy to give consultations. And yeah, I look forward to being of service. And I think
Can you take some questions?
questions. Yeah.
Yeah, I think it was a great presentation. Thank you very much. It's covered exactly what I think people need to know in order to understand how to avoid making contracts by accident, and why they need to work with an attorney sooner rather than later, even on an ultra low budget project. So I'd like to take a moment to really thank Justin for coming and speaking today. Somebody who watches this thing is going to manage to avoid a huge lawsuit, or just because they had an opportunity to watch this before they made a huge mistake. So I want to really thank you, Justin. I think you made a big difference.
All right. Thank you, everyone.
Take care, everyone.
Bye-bye.
Bye.